Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for October 20th of 2025. I'm talking to you from a cold and rainy New England.
As opposed to on the road somewhere, which is
I
nice.
suppose, yeah, well, I'm on the road tomorrow, so but it's I got my nice fall shirt on, nice fleece flannel, keeping me warm.
Well, I'm sitting here in Florida looking at palm trees and a lake in a t-shirt. So,
There you go.
okay, so let's start in New York, back to my hometown,
Hmm.
um, where we're going to go to Long Island, Nassau County, and we have a decision which, in many ways, is not unique. As you know, there are some interesting portions of this, but basically, what happened is a fire chief yelled at somebody, and the court correctly notes
That's a
that.
big surprise, right?
Yeah, exactly, right. And but the individual apparently lied about why they couldn't go to a detail. So the chief got upset when they saw the woman at in the firehouse, and it's like, "Oh, you said you had to go to work," and uses some foul language, inappropriate. But what then happens is the disciplinary committee under the department end, and I know this. I think this is Glenwood. I think is in Oyster Bay, if I believe. I think I represented the neighboring company. This is not my case, but nonetheless, but they're not part of a district. They're just a company that contracts with the town, I believe. So they don't have a board of fire commissioners. So they act under their own bylaws, and the court basically says, "Listen, you didn't follow your own bylaws." But there are two really interesting things about this. So as the court says, listen, you didn't follow your own bylaws, so we're going to throw the discipline out. The court says two really interesting things to me. One they said, one they didn't say. The first is they said the hearing committee, the disciplinary committee, can't act as a prosecuting board.
Big.
I
Yeah.
find that interesting because that's
Mhm.
not universal. For
Oh,
ins-
oh, it depends on how you look at it. It in practice it may be common. In constitutional law, our adversarial system does not allow anyone on the prosecution side to then serve as an adjudicator.
I agree. However, the ways in New York, which the laws set up, General Municipal Law 209L
Mhm,
specifically, which could be applicable here, but the judge doesn't reference,
mhm,
is a disciplinary process. And what it says is you appear before let's say with a district or a village board, you appear before the board of fire commissioners.
mhm,
And then the board holds a hearing. Now, common practice, I always do it. We appoint a hearing officer.
mhm,
But the law doesn't say that. So and let me continue a little bit on this. The law doesn't say that that the hearing panel cannot be they're not the prosecutor, but it doesn't say, listen, we've received a complaint. Here's the complaint. We're going to call witnesses to talk about the complaint, and then we're going to call the accused to talk about the complaint.
mhm,
Now, whether that's acting as a prosecutor, I think it is, right?
mhm.
Or whether you're acting neutrally to say, well, we received this complaint, and that's, I think, really how the law is. So we're going to hear both sides,
Right.
right? But here, the judge says, no, the board acted as its own prosecutor. And I agree, that is not substantive due process. I don't think that's procedural due process.
Right.
And it's not a good practice. But I just want to point out when the board is presented with a complaint, depending on how the bylaws are written, the
Mhm,
board could act not as a prosecutor, but to hear the complainant,
mhm.
right, who is kind of like the prosecutor, and
Yep.
then to hear the defense. But I thought
Well,
that's
I,
not a common issue for a judge to raise.
it's not, and I think it's important, and I think it shows this judge understands due process, in my opinion. And I go through this a lot of detail in my discipline class. But when you think about legal systems, our legal system is adversarial. And you could say it's on the criminal side, but it goes beyond into discipline as well, whenever someone has a right to due process. So you have the investigators and the prosecution on one side, you have the defense on the other, and we have a neutral party in the middle. Okay, so that's fine. Now, some places consider the adjudicator, the neutral, to be allowed to do investigations. Okay. Well, that's sort of what the
Yeah.
department did here, okay?
Right.
And that they
Right.
get to call the witnesses they think are relevant. They get to cross-examine the witnesses and all of that. Now, I say, and many departments do that, they do it without even realizing it, okay? Here's the thing. If you think that a neutral can serve in an investigatory function, you'd love China, you'd love North Korea,
Yeah.
you'd love Turkey,
Right.
okay?
Russia.
Because they allow Russia, they allow that.
Right.
Okay, okay, not in our system.
Right. Right.
Okay,
Can't
we're an
be biased.
adversarial system.
Right.
You can't
Right.
do that.
I
Okay.
I
So,
agree.
and I'm so glad. That's one of the reasons why. I mean, the big picture is just that important. And I hope I don't embarrass any of the people involved in here by highlighting the case. But I think it's so important that we get that out there. Okay. And if you don't mind, I want to put up something on the screen and hopefully, let me just make sure I'm not going to have anything behind it. But I wanna just go over a couple of things on this case because it's so important in my opinion. It's so important and it's often misunderstood. But I just want to put up my perspective
Right.
on disciplinary timelines. Okay, and what I mean by that,
I see a
uh,
tree.
say it again.
It's a tree.
It's a tree. Yeah, no, I gotta get
Uh,
my I got to get my thing up there. So, but all right, all right. Well, that'll be good enough. Okay, let me just see if I can stretch it a little bit here. There
yeah.
we go. Okay, so there we go. So
Yeah.
we
Technical.
don't think about discipline in a linear way. We just sort of, and they never teach us this in law school. You know, they don't go through this
Right.
in this way. Okay, but we have a firefighter that does something wrong. Okay, well, when the department becomes aware of it, we call that a complaint. That's not charges. You can't have an individual member saying, I'm filing charges against you. They file a complaint.
Right.
What should happen next is the department does an investigation. At the end of the investigation, the department, and usually it'll be the fire chief, now in this case, it'd probably be the board of directors, whoever, makes a decision to file charges. Okay. They confused all of this. They had an individual member who was upset, file charges. You
Right.
can't do that. Okay. So then we have, and again, there's a couple of different models. Let me just put up a different model here. This is what we call the post deprivation model. So this is where you can be found guilty. Okay, this is where, the department makes a decision to file charges. This is where you're found guilty. And then if you don't like that decision, then you can request a full-blown due process hearing.
Yeah.
And then that happens downstream. Okay. The other option, or one of the other, there's a couple of options, but one of the other options here is that Loudermill hearing where you call the member in and you tell them, this is what you're accused of having done wrong. Now you have an opportunity to explain or rebut. You don't necessarily have the opportunity to bring in witnesses. That'll happen at your full due process hearing, but you at least have the opportunity to explain or rebut. Then the adjudication happens. That's guilty, not guilty. What's the appropriate penalty? And then if you don't like it, then you go on for your due process hearing. Okay. So in the post deprivation process, you don't have that Loudermill process. Okay. But when we understand it that way, the mistakes that this department make are obvious. Okay. Because they allowed a member to take it from here to here. And then you have the hearing body trying to do an investigation. Well, no,
Right.
it's
Right.
you got it all backwards. Okay. And regardless of what state law says, state law also says volunteer firefighters in the state of New York have a right to due process,
Yeah.
right? Can only be
Yeah.
disciplined for cause, a just cause. So that I think is one of the big lessons that I took away from that decision.
No, I agree. And there's one other thing, but you won't see it here. It's because you don't see it here,
Mhm.
which is, and so I just I won and then lost a case recently and won another case. And I say win or lose. I got good decisions in both to say, listen, the hearing's thrown out. But in one case, the judge doesn't order another hearing, says, but it's before a board of fire commissioners, and you can't replace the board of fire commissioners. And they say,
What if
listen,
one of them's conflicted?
well, the whole board already ruled in violation of their due process that you were guilty. So they're all conflicted, right? But in another case, more recently, last week, a judge decided well, even though I threw out the chart, threw everything out, I'm sending you back for a hearing before the same entity. And I said, they already decided he's guilty. How can you throw him? How can you, right? And
Right.
so, anyway, so the judge
Yeah.
avoids talking about the issue. But here, notice,
Mhm.
they don't do anything. They just throw it out. What normally happens in a fire company discipline is because they're not elected officials, you can replace them with other people, right? Normally in a fire company type, okay, we're throwing the charges out, we remand it for a new hearing, and you say, but you have a right to a neutral arbiter, and you have to replace the people on this committee. This judge doesn't do it. She just throws it out and doesn't even send it back. And that's different.
Yeah. Yeah, that is it's an interesting aspect of it. But you bringing up something that what happens when you have state law that says you do it one way, and you have also a requirement of due process. So you have the 14th Amendment to the U.S. Constitution, all the Supreme Court cases interpreting that, going in a different direction. You've got a conflict, and if they say that the only ones who can discipline a firefighter are the board of directors, the seated elected board of directors, and half of them or more are conflicted.
You can't replace them.
But you have to. And a similar thing comes up in Texas. Texas, there's a state law that says that the fire chief is the only one who can impose discipline in certain jurisdictions. Texas is kind of like New York in some ways, very bureaucratic in their structuring of firefighter discipline, pretty strict regulations for certain types of departments. But bottom line is, what happens when the chief is, for example, the victim?
Right.
You can't have the victim
Right.
serving as the adjudicator.
And presumably there's something that says in the absence of the fire chief, and for that purpose,
And that's the problem.
absent.
There's not. There's not.
Wow.
So yeah, I know it. So that creates a problem in certain not every jurisdiction in Texas, but certain ones. So it needs to be fixed by the legislature.
That's easy, right? They could. And there are practical problems. For example, take 5 boards of whatever, right? 5 members of the board of whatever who are not replaceable, right? If they're neutral, right? Because they're elected or whatever. And now a member stands up to the board at a board meeting and says, F you all, F every one of you, F you, F you, F you, F you, F you, F you, and F you. All right. And then the board charges them. Who are the witnesses?
Yeah.
Right.
And
I mean, they were.
Right. The challenge is one of the jobs of an adjudicator, the person who's going to, the independent tribunal, is to evaluate the credibility of a witness. How do you evaluate your own credibility? Of course, I believe myself. Yes, Mr. Varone was very honest when he testified. That's not, that's part of the problem.
And yet New York at least has one case, very old, I found it, that says when something like that happens, the board does not have to recuse themselves. I don't like that. There should be a provision where you can replace it with a hearing officer and a binding hearing officer, not a recommendation. Right. In any event, these are the things you, me, and other attorneys deal with daily. Yeah. And, so I think your and my caution to this fire company and all others is, before you just say, oh, it's in our bylaws, you might want to have an attorney review that to make sure it comports with due process requirements, because most times the bylaws do not.
Yeah, and again, this is a New York case, and I know some of the career firefighters may be rolling their eyes here, but what we're talking about here applies to career firefighters as well, in terms of your discipline process. For the volunteers in the other 49 states that don't necessarily have a right to due process, right. This is not something that should keep you up at night, other than if your bylaws say that you can only terminate or discipline somebody for just cause, which, by the way, I think they should, but they don't necessarily say it. So,
agreed. Okay. Well, let's move on. We're going to go to a federal court. We're going to stay in New York. And here we have FDNY EMS. FDNY EMS is part of the FDNY, at least for now. It didn't used to be. It now is. There's some talk maybe it shouldn't be. Who knows? In any event, so a federal judge, denied a request by the FDNY EMS officer to seal his disciplinary record that was mentioned in a court decision. And I'm going to sum this up. So what the judge says is, listen, you're not a third party who was just mentioned where you have some privacy rights. You're, direct party in the suit, and your disciplinary history was relevant to this case. So the judge is like, so we cited it, and you can't have it removed. I caution people about these all the time. When people sue, for example, For example, I'm defending a suit. We won it, and now we're still defending on appeal, where somebody at a board meeting, remember I just said the FU example? Same thing, but
He
this
did
one
that.
was a CUN blah, blah, blah example, calling a commissioner, and right, very hard. And I said to the attorney, I said, listen, no one reads trial court decisions. Most of them aren't published. But an appellate court decision is going to be published. And your disciplinary history, your actions, your testimony, all the bad things about you have to be recited in this decision to determine whether the decision to suspend or kick you out was arbitrary and capricious, whatever. And the judge is going to repeat all that. Do you really want to make your disciplinary history and what you did on that day a permanent record? This person obviously did. I mean,
Well, I think they thought they'd be able to keep it out of the media or out of the public's view. But
yeah, fat chance.
you know, you're a public employee, number one. We got, you know, public records issues galore there. And then, you know, like you said, the firefighter or the paramedic at the heart of this is the one that put this information and made it relevant to the lawsuit. And you know, I get asked. I know you don't hear this or see this as much as I do, but because I have my blog, I have folks on a regular basis ask me to take down articles about them because they're embarrassing or whatever. And I have a great deal of sympathy when it's the person who was sued. Okay,
Right.
when the person who was sued, particularly where the case was dismissed or whatever, I tend not to take the article down unless there's something patently false. Certainly, I'll correct anything that's false, and I allow people to provide a statement if they want to clarify anything. I usually ask them to check with their attorney and so on. But certainly, I will remove people's names and change some of the indexing, you know, to take their name out of the indexing so that it's not as obvious. And, you know, particularly, but when when A goes after B, and then A is the one that contacts me and says, I'm like, you're the one who
Put it in
brought
the
this.
public
Well,
streaming. Right.
but I'm the victim. I'm the victim. Well, everybody's, you know, everybody in their mind is the victim. Okay.
Right.
But when you were the one who put it in play and you dragged these other people through into a court system, made them get attorneys, you know, and everything else, I don't have a lot of sympathy on that end.
Right.
You know, you kind of put this out there, and
And it's
now
part of
you
the
want to hide from
McDonnell-Douglas
it.
test, right? When you think about okay, do you have an independent reason why you treated somebody the way you did other than their gender, race, ethnicity, whatever? And the answer is usually disciplinary history, right? We did this because they did these bad things. You
Yeah.
are putting it in this out there for the public as soon as you sue. You're right.
Yeah. Yeah.
Oh.
So it's tough. I try to be compassionate, try to be sympathetic to folks, but when you're the one who put this stuff out there, I'm not sure that, you know, I'm not
And
sure
you're
how
right.
far I'm willing to go.
It's a tough position because when you sue, and let's assume you're totally right, right? And
Mhm.
you're suing, they come back at you with nasty stuff. And it's
Yeah.
unfortunate. It's like testifying as a rape victim, right?
Yeah.
You know they're going to put
Well,
your
and
promiscuity or whatever into,
but
you know,
that's where if you do it right, if you're a rape victim, you're going to sue as Jane Doe or John Doe or
right.
whatever it may be, and the courts allow you to do that. When you don't do that, and you know some of these people they view themselves as a knight in shining armor with their flag and their armor. They're riding headlong into they're going to fix this person. They're going to sue them, and
Yep.
then it doesn't work out. Maybe things weren't the way you
I
perceived them
want
to
it
be.
sealed.
Case gets dismissed, and now you want me to take it down.
Yeah.
I don't know. I'm sorry. I don't have a great deal of sympathy in that case.
No, I
So
agree. And it's a good beware to everybody, right? It's
it is,
unfortunate.
and I think it's important that folks, the reason the tapestry in my blog of, you know, 15 years of doing this is that people can come here and get a sense for how are people being sued. And if I take some of those out, it doesn't provide that balance of how are people
Right.
being sued, what are the allegations, how did it turn out, and so on.
Yeah, do I want to be seen like that person, right? When you read something you're like, "Oh my God, they uncovered everything about them." Well, that's a known risk. You should, right? You should be enlightening people for.
Yeah.
Okay, I have a mixed feeling about this. I'm going to be interested to see what you think, but we're going to go to Tennessee where we have a court that reversed the awarding of disability pension benefits to a Chattanooga firefighter. So let me go through this. And I disagree with this holding, and I find it offensive, but I'm going to be interested to see what you see. So here's what we have. We have a Chattanooga policy. See if I can sum this up. And the policy under the disability benefit policy, firefighters who seek a job-related disability pension for a mental health disorder must show that their condition resulted from, here's a quote, traumatic event that is identifiable, undesignated, and unexpected. And the word we're going to focus on here, because that's what the court did, is unexpected, right? And the term, as you point out, is this is a critical, right? And the court points out this is critical because the policy limits coverage to mental health disabilities that arise from traumatic events, which go beyond that what a firefighter could reasonably anticipate as part of his job. Okay, stop here for a second. Ask your normal firefighter, what could you reasonably anticipate as part of your job? You are a prime example. You never reasonably believed you're going to the station nightclub fire.
Right.
That you can't, right? And not to speak for you, but so knowing you, right? Nobody would envision that. I have done, I think, 3 pediatric codes, 1 in a pool, 2 not. I never.
How about getting trapped under a bridge? How about getting trapped under a bridge?
Okay, yeah,
and your situation,
right? So right, so we all have, and every firefighter does pulling your first burned body, which I did in early days with other people, and the skin's coming off. Okay, so please tell me, firefighter, tell me, judges, what exactly do we expect? I expect to fight fire, but you can't mentally prepare for the stuff people are going to see. So here, what the court says is, I'm sorry, and I want to read these 3 things. So the judge says that these 3 things were not unexpected to you when you joined the fire service. Vehicle crashes involving children. Well, okay, yes, you're going to go to them, but a deadly apartment fire, yeah, maybe, but, and then an encounter with an armed man while on a medical call. Now, whether or not these actually did cause the post-traumatic stress, let's assume they did. I think the court assumes they did, but the court says these aren't enough. I'm sorry, being faced with an armed person, you may anticipate, but that's, to say that our job is so dangerous, we're not the cops, right? Fire, sure, right? And maybe medical calls, but to face an armed person, and as a result, the court says, sorry, these were not unanticipated, and so no benefits for PTSD.
I'm pulled in 2 different directions. One has to do with the state legislature incorporating unexpected in there and not clarifying it. Because you think about it, if you go to a fire and the building collapses on you, that's unexpected.
Unexpected.
Right? That's unexpected. Okay.
Right.
But if you're a Scrooge-like judge, okay, you're going to say, oh, well, any firefighter could expect that a building is going to collapse
on you. A plane crash.
But it's within the realm of possibilities. Yes. But is it unexpected? I wouldn't have went in.
Right.
If that was going to collapse, I wouldn't went in.
But how
can you say it's
anticipate the horror of some of these things?
I think number one, the legislature needs to fix that. So that's sort of number one.
Yeah.
Number 2, this is the fact that a lower court, actually was it 1 or 2 lower courts had ruled on this.
It was the admin agency, wasn't it?
Yeah, the trial court, but the Supreme Court found the wisdom to reverse this. Why?
Right.
Is this substantial? Did you do substantial justice here? I mean, can you? If I was a judge, how do you lay your head on the pillow?
Right. So because I think they interpret the word unexpected as unimaginable.
Yeah, exactly.
A very high standard.
Right.
And I'm sorry, for the many of us who's gone to deceased bodies from an unnatural cause, and especially deceased pediatrics, you can't. Is it unexpected? No. Is it unimaginable? It is. You can't prepare for that. I'm sorry.
To me, the unexpected requirement, to me, probably when the legislature wrote it, I'm assuming that they're saying that you didn't expect this to happen. You didn't expect when the run came in, you didn't expect this. Like the roof collapsing on a firefighter. Because if you expected it, you would have done something different. Well, you go on a medical run, you don't expect there to be violence. You don't expect somebody to point a gun at you.
Right.
If you knew that there was somebody who's going to point a gun, you
You
wouldn't
want to
have
go on.
gone.
Right.
Okay.
But and we can play this game. I remember I was working the ER one day. I was head of the ambulance in New Orleans, and this girl walks in, woman walks in, sorority sister, and she's all red and she's flushed and is confused. And everyone's like, "Oh, what happened?" She goes, "I don't know how I got here. I don't know where I am." So suddenly, we all figure out this is CO poisoning. So we send the ambulance back, and we go back to CO. And we find a sorority or a women house with 9 critical or deceased people. So here's the thing: I expect to see CO poisoning. Do you expect to see 9 dead women?
Yeah.
I mean, is that expected or not? This is such a stupid rule, a stupid word, and a bad judge's holding, as far as I'm concerned.
Yeah, I cannot disagree on the judge's side. I think it's a Scrooge-like decision, with no compassion. Okay, the legislature now needs to fix it. I think, but
Agreed.
it'll be up to the Tennessee firefighters and the Tennessee fire chiefs to lobby and get this fixed.
Yeah. Okay, so let's come down to Florida here, where we have a lawsuit. It's just a lawsuit, and I just want to predict you're going to lose big. And I don't mean to be mean. And one of the reasons actually comes in the next case that follows this, which is kind of interesting how they flow. But here's what we got. So we got a Pasadena firefighter. He's filed suit against the city of South Pasadena and against his labor union, alleging that he was unlawfully ordered to undergo a medical examination of a condition of continued employment. And then he claims that he's terminated in retaliation for complaining about it. So the CBA has a mandatory annual medical evaluation, which determines the fitness for duty. Now, we know these are subject to mandatory bargaining, but they are well upheld. They are allowed. Physicals, of course, right? And they have to relate to the job, but nonetheless. So, and that's going to be the issue here, a part of it. And so,
yeah, I gotta see, how does this one relate to the job?
Yeah.
Well, the one at least is in my mind anyway. You know?
Okay, so we'll get there. So he objects to his local's negotiations and then agreement to the what he calls the breadth and intrusive nature of the mandatory medical examination. It says it goes too far. I disagree, but in any event, and we'll talk about what it is.
Let's get it on the table. What are you thinking about?
The part of his exams. So he talks about a TB.
I'm thinking it's a prostate exam.
Well, yeah. So here, let's go through it. He says the exam has a tuberculosis injection. Okay.
Okay.
Right.
I think that's reasonable.
Right. And by the way, it's not really an injection. It's a prick test. Right. So
that's not one of his. I don't think that's his complaint, because part of his complaint is that it's gender discrimination.
Right.
In other words, only men are subjected to it. So the prick test for tuberculosis isn't gender specific.
But the next one, ultrasonic imaging of the visceral organs and genitals. Right. But that's male, female.
To me, that's less intrusive than fingers up the butt.
Yeah, that's definitely true. What are they? Right. Yes. No question. A digital exam, DRE, right?
There you go.
The medical, it includes a medical questionnaire, vision and auditory testing, and physical fitness. But the point he's complaining about is I presume, the imaging of the genitalias and other, inspection of the genitalia, which, by the way, prostate cancer, what do we have, a 3,000 time increase,
yep.
Right, as well as thyroid and everything else. In any event, so here's what happens. And remember these facts, because we have another case coming right after this, where I thought I was reading the decision to this lawsuit. I'm like, how'd that happen on the same day? In any event, he said the plaintiff the guy suing was originally scheduled in August for an exam. He doesn't want to go. He complains and objects about it. And he says, in any event, he's basically insubordinate. Ultimately, he gets it, right, under protest. But now he's saying, oh, you discriminated against me partly because I'm a male, and you don't give women the same exam. Well, yeah, no shit.
We don't give the guys a mammogram.
Yeah, I mean, yeah, right. And look, and 1582 or now 1580 does have mammograms for women, has colonoscopies for both, if you can afford them, as part of it, right? But also prostate imaging, et cetera. So, and PSA testing, DREs. But right, how can that be gender? It's a physical.
I get it. I got kind of a mixed feeling here. And
I'm shocked.
you think about it, if in order for a doctor to be able to go hands on you, and a medic as well, you have to consent to that, right? You have to consent.
Yeah.
And if there's parts of an exam that you don't want, you have the right to say, I don't want to have that. Okay. Now, not in the
Unless
employment
you want a
context.
job, right?
Not in the employment context. So now we couple that now with a job requirement, and then now you have that problem.
Right.
And I don't know. It's difficult. I agree with you. I don't think he's going to win, but I think it's a worthwhile topic, and I think the NFPA committee needs to really kind of address this because do we really want to be imposing? I always went to my own medical. I went to my own doctor, and our department allowed you to go to your own doctor. But what if you just went to your own doctor and now you're going to the department doctor and you're going to get the same tests? Should there be some sort of a process where, hey, why don't you just take my doctor's
You take the
information,
results.
take the
Right.
results, right, and use those rather than do this to me twice?
Right. I would
Um,
have the department doctor make the determination based on the results, but fine. Your
exactly.
physician would just be a lab, basically, someone who took
Yeah.
blood tests and gave you the results. How it
Yeah.
relates is up to the department doctor, not your own.
Right.
Right.
Yeah. So.
But the big thing I think the court's going to start with, I'm
Mhm.
betting this decision because you and I have seen this same decision 100 times.
Mhm.
I'm sorry, you are part of the union. You give up your rights to be bound by the union. And there's standard language. The judges always quote on that. And that's what you're going to see at the beginning of this. You can't complain that the union negotiated your rights away because you voluntarily participate in the union. You could get out, right?
Mhm.
He could recuse himself from the union.
Some
I'm
states maybe, yeah, some states, but
Right. And I have no idea in that state. But in any event, he's going to lose on that. And I think he's going to
Mhm.
lose generally. But okay. So let's go to California, where the California Court of Appeals has upheld the dismissal of a lawsuit, right? They said we agreed the lawsuit should have been dismissed. This is by a former fire captain who alleged disability discrimination and retaliation under the state Fair Employment and Housing Act. The court ruled that the plaintiff, the person suing, did not suffer an adverse employment action when the city required him to undergo a fitness for duty examination. And so, right, so he's out. He comes back. He was out sick for, I think, a couple days. And like normal, right, if you're gone for more than 2 or 3 days, depending on how your department writes the policy, we're going to send you for a clearance physical. And he said, well, that's retaliatory. And the court says, it's not. I mean, I don't get it. And he says, well, I was constructively discharged as a result of all of this. No, you weren't. I mean, you just had to go to a physical. That's not a change in your working conditions that's so severe as to make it impossible to be able to work there. And that's what this court was. They use a lot of words, a long decision, what I would have written in about 10 words. But I'm sorry, you can't complain about a physical. You were cleared to duty, but you were insubordinate. And the court goes on and said, you objected to this, right? You fought it. You were told to do it. I don't know. This is going to almost be the answer to the last one we just talked
yeah, it could be. I hadn't put the two of them together, but I think you may be right as far as the outcome on this one. It's it it had the appearance to me of a Hail Mary. Uh,
Yes,
and
yes.
he resigned, he went to an attorney and they said, well, we'll give this a shot, but
It's funny though, and maybe it's an unrelated topic, but when somebody comes to me with a losing case and
mhm,
I say, listen, we can't win this.
mhm.
And I say, I don't want to take it. A lot of times they're like, oh, but we're willing to try it anyway. I'm like, I don't know that I'm willing to take a case that I know I'm going to lose. And look, one times out of 100, and I just had this example, I told somebody it's not worth it, and they settled it. Now, whether they settled for $10 or $10,000, I don't know, but they got some attorney. I'm just not going to do it if I don't believe in good faith that I can win it. And this would have been one of those cases. But people are willing to take it, I guess, or they have a different opinion, a different view of it.
Well, this one was brought under California law, and California has that Fair Employment and Housing Act that is very employee generous.
As California.
Yeah. Right. So, maybe they thought that they'd be able to get some traction, at least get by the motion for summary judgment, and
And
then
try to
you're in
settle
settlement.
something.
Yeah, then you're in settlement grounds, settlement range, but
Instead, they
didn't
spent
get
a
that
ton of
far.
money and got nothing.
Yeah.
Right? I mean, they kept appealing this. That's the interesting. They lost and kept appealing.
Yeah.
We're not trying to beat up if the attorney's watching. We're not trying to beat up on you. If the client's watching, we're not trying to beat up on you. But, that's kind of the benefit of Monday morning quarterbacking everything. It's the way at least the court wrote the decision.
Should have punted. Shouldn't have gone for that field goal. Should have punted.
Yeah, yeah, you had another minute, 20 seconds left, so you should try it. No, I don't know. Anyway, so that's our cases for the week. Hopefully, this week, kind of, if you think about a theme on 3 of these cases, at least 4 of the cases are all very much advice about maybe you don't want to bring a lawsuit, maybe you do. If you do bring a lawsuit, here's the process. If you're disciplined, here's maybe some of the process as a volunteer. I don't know, but hopefully this people find this continuing educational.
There we go. Well, if you've hung with us this far, please click like and share. Please help us to get the word out. Brad and I love doing this, but it'll help us greatly if you can get other people to be aware of it by sharing it, by liking it, and certainly by subscribing. It's a big help to us, and then that will help us to keep doing what we're doing. And somebody did reach out and say, why don't we do Patreon, where people pay to watch and stuff like that. And we're not doing this for that, but you can certainly help us by coming to our classes, and certainly if you're in jurisdictions where we can represent you, certainly that'd be helpful as well. But in my case, certainly, rather than Patreon, come to my classes. That's what I'd say. So, all right, and that'll do it for another edition of Fire Law Roundup.